Today's special guest is John Stemberger, President and General Counsel of the Florida Family Policy Council. John and I bumped into each other on August 8th outside on the steps of the Florida Supreme Court before the court heard arguments in a challenge to a Florida law that restricts abortions after 15 weeks of pregnancy. The decision in this case will have very wide-reaching implications on women's reproductive rights because a law passed this year imposing a ban on abortions after 6 weeks will go into effect if justices uphold the 2022 law restricting abortion after 15 weeks. So if that hasn't confused you all, today's deep dive into abortion with John Stemberger. Stick with us, you don't want to miss it.
You're listening to A Deeper Dive with Dara, a podcast by City and State, Florida.
Hello and welcome to A Deeper Dive with me, Dara Cam. Today's special guest is a repeat visitor to the show, John Stemberger, the President and General Counsel of Florida Family Policy Council. Thanks for joining us again, John.
Sure, Dara. Great to be with you. Good to see you on the steps of the Florida Supreme Court as well last week.
Yes, that's one of the reasons why we're visiting again today. John and I bumped into each other prior to the oral arguments in the challenge to the state's restrictions on abortion. The 15-week restriction is what was discussed on last week, and what is contingent upon that is a law that was passed this year that would restrict abortions with some exceptions after 6 weeks. So let's talk about what we heard on Friday. That would have been whatever the date was then. The arguments, I wrote a story about that. The arguments centered on the Florida Constitution's privacy clause. Let me just read that for listeners real quickly. Florida's privacy clause protects the autonomy of the intimacies of personal identity and, quote, a physical and psychological zone within which an individual has the right to be free from intrusion or coercion by government. That is what the critical part of what the privacy clause says. And the justices were asking many questions about whether that right to be free of government intrusion includes the right to an abortion. What says you about what you heard during the arguments?
Yeah, so both sides did very well. I was surprised Planned Parenthood's lawyers were very articulate, very organized, very prepared. The state of Florida did well. I was surprised to see Ashley Moody sitting at the table, the Attorney General of the state of Florida.
Yes.
Shows commitment to the issue. The Solicitor General was good. I did feel like that he missed some obvious questions that he could have answered had he with the amicus brief that were submitted by a number of people. But both sides did very well. And, the court, it was interesting, the court, Justice Renata Francis, who is new, had no questions for the court. Same with Charles Canady, and Justice Larja, who rarely asked questions, also had nothing to say either. So most of the questions were carried by the other justices, of which Carlos Munoz was the lead questioner, I think, throughout the whole case, asking on the substantive questions of the issues. So obviously fascinating discussion, fascinating argument, and questions to hear from the court.
Justice Muniz is also the Chief Justice. You mentioned Justice Canady, who did not ask any questions. His wife, State Representative Jennifer Canady, was the primary sponsor of this year's 6-week abortion bill, which I want to go back. I went back and I listened to our conversation from last year, John, and I asked you what you thought the legislature would do, and you predicted that they would do exactly what they did, and that was the fetal heartbeat. That is the 6-week ban is also known as the fetal heartbeat restriction. So that is what they did indeed do, as you predicted here a little more than a year ago. One of the things that I wrote about that intrigued me that Chief Justice Muniz asked about was he said that Roe v. Wade may have been an abomination. Do you think that gave away a little bit about where the court might go with this ruling?
So there was an interesting comment. I'll need to, I don't know if you replayed it, listened to it, but he wasn't saying that was his belief. I think he was saying some people believe this, just to give perspective. But I thought it was a very acceptable comment. I was greatly moved at the end when he talked about the fact that there's an entire class of human beings. That creates a very specific picture of what we're trying to advocate for, that there's a class of human beings that have no rights under the law, and the legislature sought to protect those human beings at a certain stage of pregnancy where they can feel pain. That was the law before the court. And so he was asking that, but just to paint that picture, I thought was a very powerful picture from the standpoint of pro-lifers who are trying to get people to understand this is not a blob of flesh. This is not, this is a living, growing human being. And so that was really, I thought, one of the most powerful questions asked during the entire time.
It was a very powerful question, and some of the other justices asked about standing and things like that. And I think that Justice Muniz, the Chief Justice, really wanted, and the state actually, the Solicitor General Henry Whitaker, he urged the court not to rule on standing, but to rule on the merits. And so that was, I think we can see like a decisive ruling from the court on what exactly the privacy clause means. Now, what happens if the court does uphold the 15-week restriction and the 6-week ban goes into effect? Many of the arguments about the 6-week restriction is that many women, that it's effectively a ban on abortion because most women will not know that they are pregnant before time runs out for them to be able to get access to an abortion. And I'm wondering what you say about, I overheard a little bit of a discussion on the steps of the Supreme Court between you and Billy Townsend, who is self-identified, his Substack, I think, is the moniker Public Enemy #1. He's a former reporter who is a Polk County resident, and so what he was asking you about enforcement. How will the state go about enforcement? And we can talk a little bit about whether the argument that the privacy clause that is up for debate in abortion, you have argued in your amicus and in op-eds that I've seen, that is an informational, that covers information, and keeps people safe from government intrusion into information. Can you expand on that a little bit, and then we can talk about enforcement?
Sure. So the origin of the amendment starts in the 70s when you have Watergate, you have wiretapping, widespread wiretapping, by the way, which is discovered by the government and by the media. You have TCP/IP first being invented, not by Al Gore, but by a committee of people who are understanding the internet, and it's being used. You have wire transfers, SWIFT, international wire transfers happening for the time. You have fax machines. All these things are happening in the 70s. And Carter commissions a privacy commission. And one of the results of that commission, when they issued their report in early 78, was, hey, we need to encourage states to adopt freestanding independent privacy rights because there's no informational federal privacy right in the federal Constitution. So Justice Overton at the time was chairman of the first CRC that ever met, and the body that meets once every 20 years in Florida.
That's a Constitution Revision Commission. I'm sorry, I didn't mean to interrupt you.
Thank you.
Yeah.
No, listener, that's very helpful. And so they meet and they say, look, we need to look at this right to privacy. And so all of the debate, all the discussion, all of the records of the archives that are available, there's not a single discussion about abortion, about right to privacy being conduct related, right? It was all informational privacy. It wasn't about substantive due process, wasn't about personal autonomy, didn't ever reach conduct. It had to do with informational privacy. And so it was put on the ballot, and in 78 it actually failed. And one of the reasons it failed there, and this is the question that was asked to the state's Solicitor General by Justice Munez, and he said, what about this second clause? Well, the second clause was put there by the 1980 legislature in a joint resolution because the media all opposed it. And the reason they opposed it is because they thought they would not be able to get information, right? Because that was the gravamen, that was the thrust of the entire proposal by the CRC back then. So the legislature, when it passed the joint resolution in 1980, after it failed on the ballot in 78, they still wanted it. They added the second clause. The second clause talks about nothing in this clause shall prevent media or press from getting information, going to public meetings, public records requests, that kind of thing, to show that it would be an issue. Now, in 1980, the media still opposed it, editorial boards, the First Amendment Association of Florida, but at least it passed in 1980 by about 60% of the vote. But I think it passed in part because they amended it to make it clear that this would not prevent people from getting public information, especially the media. It was informational privacy, it was never conduct. And then speed up 9 years after it's adopted, the Florida Supreme Court, then in 1989, Justice Landers Shaw, writing for the majority, he basically said, here's a fundamental right to an abortion, which extends to a minor, even over parental consent, in striking down a parental consent statute that was passed by the legislature in a special session signed into law by Governor Bob Martinez back in the day. And so that's how we get in Re TW, which is our Roe versus Wade in Florida, which is the case that was being discussed by the Florida Supreme Court in the argument last Friday.
And it was interesting, the state noted, and even the plaintiff's attorney conceded that there was no discussion of abortion at the time this amendment, and prior to the passage of this 1980 amendment, that wasn't really part of the debate about the amendment, even though she argued that it was understood, that privacy was understood to, that there was a lot of talk about privacy addressing abortion because of the Roe decision, but there wasn't, and I believe there was actually a legislator who said that this has nothing to do with abortion when he was arguing in favor of the amendment.
Yeah, so Jack Gordon was the Senate sponsor, who is no longer with us, a very powerful Democrat from Miami. Also, Ed Dunn, who I knew personally, he went to the Catholic Church in Daytona Beach, Florida. He was pro-life, a conservative Democrat. He said to Gordon, hey, does this include abortion? And Gordon says, no, absolutely not. He affirms it twice. So that was actually in the state's brief and a clear on the record. But what's interesting, Dara, is that the court, as a textualist court, is not supposed to consider legislative intent or debate. They're supposed to look at the plain language of the, as the people see it, and then vote for it and ask, what was the public intent? What was the public meaning of that? And so that was another question that was asked by the state. What are the tools, he said, what are the tools to help us understand what this means? And it wasn't a real clear answer given. One of the briefs submitted by Senator John Grant, actually by former Justice Alan Lawson and by Jason Gonzalez and his law firm, they gave basically an exhaustive list. They did a study of all of the times privacy was mentioned in 1980 in the news or anything like that, and virtually all of it had to do with informational privacy. It did not have to do with the right to abortion at the time. Again, showing that what was on the people's minds were this kind of invasion of privacy. Now we don't care about it today, right? With smartphones and everything else, kind of informational privacy is kind of out the door. But back then it was a growing concern as to what it's going to look like in the future. And that's what people had on their minds, not abortion, which was already a fundamental right under Roe versus Wade and not threatened in any way at the time.
And so this conversation that I was listening to between the two of you had to do with enforcement. So how would the state enforce a 6-week ban on abortion Would you have to have a registry of pregnancies if someone has a miscarriage? How would the state make sure that someone, for example, didn't get an illegal abortion or get medication from another state? How would that happen, and would that pose a threat to an intrusion in that kind of privacy that you're talking about in terms of the government not being able to snoop into your records?
Well, first of all, that's a great question. All the enforcement and all the penalties are directed toward the abortion clinic and the physicians performing the procedure, not toward the mother. And you can go back far back as the common law, in English common law, and we never directed punishments at mother. Before Roe versus Wade, no state had any punishments for mother. It's always been to the clinic and the physicians. So that's the who would get the enforcement, who would get the penalties. And basically, it would have to be some woman who reported that, they had an abortion and it was done improperly. I was surprised after Roe versus Wade. I thought we'd see this underground kind of network of, doctors doing illegal procedures, but it looks like they really are following the law. I think they're concerned about a RICO case where there would be a Racketeering Corrupt Organizations Act claim or something like that, where they would be discovered. So it looks like they have been following the law because they're shipping women across state lines into other states now and things of that nature.
You mean following the U.S. Supreme Court's overturning of Roe v. Wade in what's known as the Dobbs case? You thought that would trigger this underground activity?
Yeah. So what I was referring to is that I was thinking that the abortion doctors, would violate the law of the state that they were in because Roe allowed each state to regulate abortion however they saw fit.
I'm sorry.
Yeah.
I see.
And some states prohibit it completely. Some states allow it completely. And so I thought that there would be this underground network. And instead what's happening is I think they're moving women around jurisdictionally across state lines to get the procedure instead of violating the law and doing them in states. It could be happening in states like Texas and others, but we're just haven't seen it happen anywhere. So in Florida, when that happens, it would be, the same way every other thing is regulated. The doctor, I think, would be on notice, and I think they would probably risk losing their license to practice medicine. So they probably would follow the law, self-enforced, and not attempt to violate the law. At least that's what we're seeing for the most part.
I saw a story that said that in Texas has a fetal heartbeat ban that went into effect not long ago. And I saw a story that said infant mortality rates have climbed following the passage of that law. Is that something that you think should be a concern in Florida, or do you think that's something that could occur after these heartbeat bills?
Yeah, your friend, the reporter, sent me that data. I haven't looked at it yet, but is there any time we can protect the health, safety, and welfare and the life of human beings, especially children, unborn children and born children, we should look into that and find out what the source of that is. But in Texas, there have been literally thousands of unborn children that have been protected as a result of their heartbeat law. And so someone has to certainly weigh that in perspective. Our perspective is we want to see every child protected under the law. And so, that's our presupposition in the whole thing.
Thanks for listening. Our guest today is John Stemberger, President and General Counsel of the Florida Family Policy Council.
Here at Deeper Dive, we want to hear from you, the listeners. We invite you to send your questions, comments, and feedback to our mailbag. You can reach us at deeperdive@cityandstatefl.com. That's deeperdive@cityandstatefl.com. Get your 2 cents in by sending us an email.
Welcome back to A Deeper Dive with Dara. What about people who argue that you're putting the value of you're placing the value of one life above the other? Talk to me about why that's not a valid argument.
Well, help me understand that. I don't see that. How, in what way would pro-life advocates be putting one life over another?
If a woman, for example, a young girl is raped and she's too afraid to report it, or if a woman does not want to have a child, does not want to give birth, does not want to have becomes pregnant, but does not want to be a mother, does not want to carry the child to term. And you have to, in order to qualify for some of these exceptions under the 6-week ban, it is quite rigorous. To meet the eligibility criteria is quite rigorous. So some of the opponents of the law argue that you're placing the life of the unborn over the life of the mother.
Yeah, I don't see that. First of all, it's clear that under the heartbeat, for the first 6 weeks, there are exceptions for rape and incest. There are no exceptions under the 15-week bill, so that would both go into effect together. So in the first 6 weeks of pregnancy, there would be exceptions for rape and incest. After that, in the 15-week mark, there would be no exceptions. So that would be the law if the court strikes down in rate TW and finds there's no right to privacy in the Constitution. Secondly, I think that I can understand a woman who does not want to be a mother. I can understand the fear and the uncertainty of that whole situation. But our position is that we want to help her and realize that, hey, we can love both of you. We don't have to destroy the child within you that's growing within you because you have fear, because you have concerns about finances or whatever it is. And so it is rare to have obviously giving birth to the mother. There's the risk to that, but that's not something that's overwhelming. And so unless there's some, fetal fatal abnormality where the child's going to die, or unless the mother can show that her life is in danger, that's clear. If the mother's life is in danger, if there's an ectopic pregnancy, certainly she has the ability to terminate that pregnancy. But those are very rare instances.
So there were about 68,000 abortions in Florida in 2022. Do you think that we will have that women will have the resources? I don't know how many of those were performed after 6 weeks, but I'm assuming that a large number of them were. So do you think that groups like your group and other organizations are going to have the resources to provide to that number of women who become pregnant?
Yeah, absolutely. There are about 200 pregnancy centers. These are private institutions, nonprofit groups. These are women that just care for people. The state has provided them and really put their money where their mouth is. Over $25 million in funding. There's also other streams of funding that's available to them. In addition to their private funding, I'm going to be going to Miami in about a month to do the keynote speaker at one of these pregnancy centers to help them raise money. And so they give free food, they give free diapers, baby clothes, parenting classes. These women are remarkable what they do, and they've gone under the radar for the most part until Roe fell in the Dobbs case. They've been attacked horribly around the country. And these are just women trying to help people. And so, yes, that's certainly a concern. We have to care for women, and that's exactly what we intend to do, whether that's through private funding or through also public funding as well. Under Chris Sproul, as Speaker of the House, Medicaid was extended for a full year to pregnant women who needed those resources. And so quite a bit has been done to take that concern into consideration.
I remember, and everybody knows that I'm an OG. You're one of my OGs, and we've been around for a minute. I remember when the first year that the state funded the pregnancy support centers was under Jeb Bush, and he very quietly got, I believe it was $500,000 that first year. I could be wrong, but I believe it was $500,000.
That's right.
And it created a very strong clapback after people realized what had been passed. That was when that began. I want to shift a little bit to the, there's a proposed constitutional amendment.
Darren, were you there during the special session in '89 with Bob Martinez? Wow. Okay.
I was.
You have quite a bit of history. 'Cause
Yeah.
I was working for Ken Connor at the time, and I wrote an
I
amicus brief
remember
on
Ken
behalf of
Connor.
38 legislators. Yep. And remember, you were part of that original press corps and still around today.
Isn't
talking about
that
OG Florida
amazing?
Press corps.
That shows you how old I am,
Yeah.
right? It's a very different press corps today. But I wanted to shift. Thank you for helping remind all our listeners to exactly how long in the tooth I am. I wanted to talk a little bit about this. So before we shift to the proposed constitutional amendment, let's talk about where you think the court's going to land on the arguments that we just heard.
Yeah, so a couple of the justices were very interested in the standing issue. Standing is a legal doctrine saying, do you have the right to this court? There's a question about, these are not women. There's doctors and medical medical abortion doctors that are bringing the case. And so how does a third party have the standing, the state, the Planned Parenthood argued that the fundamental right to get the abortion is contingent upon the doctor's practice. So there was that kind of discussion. It's possible they could rule narrowly on jurisdiction and on standing, saying that we're going to uphold the bill because you don't have the right to be in front of the court, because you don't have the right plaintiff, you don't have the right people suing. But I don't think that's the case. I think that's more likely.
Then you'd have to go through the whole song and dance again when you have a woman who is pregnant and wants an abortion and is facing a deadline or something like that.
Right, that's what happened in Ray TW. The case is called in Ray TW because it's in reference to TW. It was a minor. We kept her identity confidential, and so that was the name of the case. Here we have abortion clinics bringing the cause of action, bringing the appeal, not women per se, in their personal capacities. So that was a discussion of the court. But I do think the court is going to rule on the substantive matter, and I think I think the pro-life community is going to be very happy with the outcome, because I think it's pretty clear. There's no history, tradition, nothing in the privacy clause, whether the plain language of what people were thinking about at the time or the history behind it has anything to do with really abortion. It had to do with informational privacy. So it's a judge-made right. And so I think that the court is going to rule that there's no right to abortion in the Florida privacy right that was adopted in 1980 by the people of Florida.
So thank you for that. So there's an effort now to get a proposed constitutional amendment on the 2024 ballot that would seek to prevent abortions. That would seek to bar laws that restrict abortion, quote, before viability or when necessary to protect the patient's health as determined by the patient's healthcare provider. So they have reached the threshold for Supreme Court review. The Florida Attorney General has not sent that proposal over to the court to review yet, but she has about probably 4, 5, 6 weeks left in order to do so. What do you think the chances are of that making it onto the ballot?
So I think there's a fairly good chance. If you don't have time or you don't have money on your side, then you have a problem with these things. They do have a time issue, but they do have money available to them. So I think that it's likely that it will get on the ballot. I was not aware that the Attorney General had been delivered. They have 30 days once the Attorney General receives it. I know that the Division of Elections has to certify and then submit it to Secretary of State, submits it to the Attorney General. I have not been aware that that's happened yet.
Okay, I might be wrong about that. They have reached the number of thresholds and the number of congressional districts to trigger the review.
That's correct.
Yeah. So do you think that the court reviews these proposals to see if they meet the single subject and requirement, and if they are misleading to voters? What do you think about the constitutionality? Whether the four corners of this amendment would be is constitutional and whether the court would rule to place it on the ballot.
Yeah. So there's 5 ways we can amend our Constitution in Florida. One of them is a citizens initiative. That way citizens can collect petitions, they get it on the ballot. They have to collect the first 25% to trigger a review by the Florida Supreme Court. Now, the legislature, when it does a joint amendment, doesn't have this. The Constitutional Revision Commission doesn't have this. The Taxation and Budget, because they assume these are people that are experts. But if a group of people just amend the Constitution, they have no idea what the language could be, right? So they want to make sure it's a single subject. So there's 2 things the court does. It looks at whether this is affecting a single subject or whether it's dealing with multiple topics. And it asks, is this language in the summary, is it actually deceptive or misleading? Because voters actually, many people don't know this, when you actually vote on a constitutional amendment, you're not actually seeing the actual language.
Right.
You're seeing the summary of the language.
You see the ballot summary, right?
The court, sometimes the language, it's legal, right, and you don't know what the impact is going to be, so the court looks at the summary because that's what the voters are going to look at. Sometimes the summary explains what the language does. And they've done a fairly good job. This is fairly tight language because with the exception of one sentence, the language of the amendment mirrors the summary. So it's going to be very hard to argue that it's deceptive. There's arguments that can be made. Now, I think the language itself of the amendment inherently within itself is very deceptive and very dangerous and very extreme. But because it speaks out of both sides of its mouth saying, oh, yeah, you can restrict abortion after viability. But then it says, or as determined by any patient's healthcare provider to protect the health. Health is a very broad concept. In the companion case of Roe versus Wade, it's called Doe versus Bolton. The Supreme Court laid out a very liberal definition for health using the UN definition. And it's basically any distress, headaches, nausea, anything like that, basically the state of being pregnant, the kind of symptoms, can invoke the health. So on one hand, it talks about restricting abortion before viability, but then it talks about the health. And every time you talk about health in the abortion context, it's an extremely broad standard. And so what you're going to have is this is going to strike down every single regulation protecting the safety and health, welfare, and the mother involved, and all the clinic regulations, 24-hour waiting period, all that will go out the door if they're successful. But so I do think that the court it's going to be interesting to see how the court rules. Some people think, oh, this is just a Republican court. They're going to shut down. No, this is a court that is really looking seriously at the language involved. I mean, I remember when Renatha Francis was put up the first time, you had a representative out of Orlando, a Democratic representative, who said, hey, this doesn't meet the constitutional requirements. She hasn't been a lawyer for 10 years. And Governor DeSantis thought he would do that. Well, the court ruled against Governor DeSantis. So it showed that they were straight shooters. They're not political players here. And I think we're going to see that over and over again. So it's going to be interesting to see. I don't know the outcome. It's a very good question, and I'll certainly be there during the argument. Language as well.
Well, so will I'm sure, if I'm still around, being so ancient. One thing I wanted to ask you about before we close, and thank you for joining. For listeners, yes, that was thunder. Yes, it is summer in Tallahassee in Florida. So we are having a serious thunderstorm here right now. I wanted to ask you about the abortion Governor DeSantis is running for president. Ex-President Trump or President Trump is seeking re-election. So they are running against each other in a very contentious Republican primary. President Trump has said that Florida's 6-week ban went too far. And I'm wondering how much of an issue the abortion will be in the GOP primary and maybe even in the general, and whether you think that Florida's 6-week ban, I know it helps with Christian conservatives and Republicans like yourself, but is that going to help or hurt Governor DeSantis in the primary?
Well, he's on the record already in the state of Florida. He's signed the 6-week bill. He's very much a federalist. He's very much a policy person. And so he has not taken a position on what the federal law should be or what congressional act should be. I disagree with that, but I understand and respect the position that he's taking. And so that's been very interesting. If the 6-week ban is upheld, we'll certainly present it front and center for the campaign, and he'll have to own it because he obviously signed it. He supports it. I think at a federal level, he has a constitutional and a principle, structural issue with the federal government engaging in these matters. But I think that, Dara, the problem is nobody's thinking anymore. We're all feeling. We want to be entertained, right? That's what we want. And that's why I think Trump is a very entertaining candidate, right? So people are not thinking about policy. Us activists do, right? But most Joe Lunchbuck want to feel their way through the election. How do I feel about this guy, And then they want to be entertained and all of that. So really, I don't think it's so much of an issue. There's lots of other issues in the general election. There's immigration, there's the economy, inflation, there's the whole trans issue out of control with young people. So I think that there's a lot of other issues involved. Abortion will be one of them in the general, but I don't think it's going to be the defining issue in the general election.
Have you endorsed a candidate in that race?
I have not yet, no.
Are you going to?
We're considering it.
I think Governor DeSantis, didn't he speak to your group this year?
He did. He was our keynote speaker at our last annual dinner.
Folks can't see, but John has an ear-to-ear grin on his face as I'm asking him these questions. So I'm glad that I'm giving you some pleasure.
That's not fair game in a podcast. This is supposed to be visually off the record.
Okay. Do you want me to have Ryan take that part out? I can have him edit that out.
Look, I think Governor DeSantis
now he's very sober looking.
nature.
Let me just let readers know John is now very sober looking.
Yeah, no, I think Governor DeSantis is a force of nature. I think he's very principled. There's a couple things I disagree with him on as governor, the gambling issue and other things, but for the most part, he has been amazing from our perspective. And so, Trump is kind of a street fighter, but I think DeSantis is more of a strategic warrior. He actually is not just shooting from the hip. It's not third dimensional chess, right? It's actually, he's a guy that has a strategy for everything, and he implements the strategy. And so I think that's got to be respected. So.
Well, thank you very much, John Stemberger, President and General Counsel of the Florida Family Policy Council. We'll have you back on after the Supreme Court rules on maybe this case or the proposed constitutional amendment. It's always a pleasure chatting with you.
Thank you, Dara. Likewise.
A Deeper Dive with Dara is a podcast by City and State Florida, hosted by Dara Cam, produced by Ryan Daly, and music for the podcast was recorded by Periodic Labs, LLC, and performed by Ryan Daly and Danny Reyes.